Good morning, everyone, and welcome to a very special conference today on disability and international humanitarian law. My name is Anne Fitzgerald. I'm the director of the Balsillie School of International Affairs in Waterloo, Ontario, Canada. I'm delighted to welcome all of you to today's conference, held in partnership between the Balsillie School of International Affairs, the Canadian Red Cross, Conrad Grebel University College, Project Plowshares, and Wilfrid Laurier University. Importantly, I would like to start the conference, which pertains to human rights, with a land acknowledgement. For those in the audience who are tuning in today from outside of Canada, one of the actions we take to advance reconciliation and human rights between settler and Indigenous peoples is to reflect on our relationship with the land and the continuous process of colonization that deeply impacts our work. Acknowledging the land is a process of deliberately naming that this is Indigenous land and Indigenous peoples have a right to this land. The Balsillie School of International Affairs is situated on the Haldimand Track, the land promised to the Six Nations, and includes 6 miles on either side of the Grand River, which is the traditional territory of the Attawandaron, the Anishinaabe, and the Haudenosaunee peoples. It is particularly important that we here at the school acknowledge the land on which we are situated in all that we do, including today's conference. Yesterday evening, we were privileged to hear a fascinating speech by Professor Arlene Cantor from Syracuse University, who discussed the nature of disability and international human rights laws under situations of armed conflict. Today, we are thrilled to welcome all of you back to continue the discussion, to ask questions and expand our knowledge and awareness of what international human rights and humanitarian law is and how it relates to disabled peoples and bodies today. Before we begin, I'd just like to mention some quick housekeeping items. First, today's conference is being recorded and will be posted to both the BSIA and the Red Cross YouTube channels later this week. Secondly, there will be an opportunity to ask questions during the breakout sessions at 1:20 p.m. We ask that you keep your audio and video turned off until that time. And finally, the conference organizers will be assigning participants to the breakout rooms. So you don't have to worry about where to go at that time. We will find you a place for a great discussion with a colleague. To officially kick things off, I am thrilled to pass the digital microphone off to Catherine Gribbin. Catherine is the Senior Legal Advisor for International Humanitarian Law with the Canadian Red Cross, where she has worked for over 10 years. In this position, she oversees Canadian Red Cross international humanitarian law activities, including the training of Canadian Armed Forces and the engagement with the Canadian government on issues concerning the implementation of international humanitarian law. Today promises to be a fascinating event, and I look forward to the shedding of more light on issues concerning disability, international humanitarian law, and how we embrace, enhance, and protect it going forth. Catherine, the floor is yours. Thank you very much.
Hello, and thank you so much for the very kind welcome. It's wonderful to be here with you all on the virtual conference room floor. Thank you so much to all of our partners and all of the team who have put together today. I too would like to start with a land acknowledgement. I am zooming in from Nova Scotia, which is the traditional land and ancestral unceded territory of the Mi'kmaq people. This territory is covered by the treaties of peace and friendship, which the Mi'kmaq, Maliseet, and Passamaquoddy people first signed with the British Crown. And these treaties did not deal with the surrender of title, nor of the land and resources. So very, very important land acknowledgement in these times. So I have the great pleasure of spending about the next half an hour with you to do an introduction of what is international humanitarian law, For those who joined last night, we had an incredible walkthrough of the Human Rights Treaty, really that was diving deep into treaty rights and human rights related to persons with disabilities. And what I'm going to do is I'm going to bring us into another body of law, looking at more deeply international humanitarian law. So we're going to spend the first little while of the presentation unpacking what international humanitarian law is and isn't, do a little bit of a comparison between international humanitarian law, or IHL, and human rights law, a little bit of a compare and contrast, if you will. And then we're going to dive deeper into what is IHL, when does it apply, who does it apply to, also that you have a better understanding and knowledge to be able to take in all of our incredible panelists later on this afternoon. And I'm really hoping everyone is able to stay with us for that afternoon for the really incredible presentations that we have to look forward to. So Joanne, if I could ask, and actually before we start, I wanted to get everybody ready to have their fingers on their keyboards. I have some questions that I'm going to be throwing out to you. I'd love to see lots of answers coming from you via the chat function. So I'm going to be asking those questions out loud and asking you for your thoughts and answers to those questions. And then I'll be able to respond to them throughout. So I just wanted to get you ready for hopefully what will be a little bit of an interactive presentation, not just me Skyping or not Skyping, Zooming into you. And really I look forward to seeing your responses on the chat function and hearing from you. So Joanne, if I could ask for the first slide to be, or for the presentation to be launched, that would be wonderful. And Joanne is going to be very, very kindly, she is going to be showing us the presentation throughout. So I thank Joanne in advance for her help in this. So for international humanitarian law, Joanne, if we could click to the next slide. IHL is part of public international law, and in its functionality, just like what you heard last night during the keynote address, there are a lot of interactions between law when we look at the overall legal framework that applies during situation of armed conflict, situations of peace, and looking at all the different ways by which states, non-state actors, and individuals all interact with each other. But when we try to unpack what is international law and then try to dive a little bit deeper into the specifics, it's always important to understand that there is a relationship and connection between them. So when we look at the application of situations of armed conflict, we realize that there are a number of bodies of law that apply and influence and impact that situation. One of them, as we know from last night's keynote, is obviously international human rights law. So you can see that that's one of the bricks there in our wall of what makes up international law. In addition, we also have the law related to the right to the ability to be able to use force. So that we're going to unpack shortly. We're going to find that in the UN Charter, and that speaks to the states' relationships and their ability and right, or the fact that they actually under the UN Charter should not use force in the first instance. Then we have the law related to the environment. We have law related to the protection of refugees. And so when we talk about international humanitarian law, it's important for us to understand the broader context that it is, it's enacted in, it exists in, and all the interactions that take place between it and the other bodies of law during that real-time, real-life situations that we're going to be talking about throughout the rest of the day. Joanne, next slide, please. So international humanitarian law, and if you could click, I think 2 more clicks, Joanne, just to get all of the images up. Ooh, and 2 more. There we go. Wonderful. 1 more. Wonderful. That's it. Thanks so much, Joanne. So what is international humanitarian law? It is the body of law that governs the interaction between states and non-state actors during times of armed conflict. It applies during that situation of armed conflict, and it is an attempt to limit the destruction that results from armed conflict. So when we're looking at the goal and intention of armed conflict, it is an attempt to put into law the notion that even wars have limits. So yes, war can take place, but international humanitarian law is an attempt at limiting the destruction, the death, including the death of military personnel and combatants on the other side. So, and I want us to start thinking about that specifically in relation to today's topic of looking at disability and IHL, and how when we're looking and understanding IHL, that cross-cutting nexus of protection of those and persons with disabilities and the actual steps that need to be taken to prevent disabilities and the furtherance of problems related to disabilities, all under the framework and the response to armed conflict. So I just plant that seed with you so that way we can come back and revisit that throughout the presentation. So on the screen, you see a difference between the right to go to war. So that's the law related to the right and ability to be able to use force in the first instance, and international humanitarian law. So the law that applies during times of armed conflict. So I have a question for you. And again, this is your first chat function, so getting those keyboards ready. Does international humanitarian law apply even if the war is illegal under the UN Charter? So again, the question is, does international humanitarian law apply even if the war is illegal under the UN Charter? So I see that there's over 80 people on the call. So yes, it is. I'd love to see, let's see if we can get 50 or 60 responses. Fabulous. Look at this coming in, seeing lots and lots and lots of answers. Wow, and a unanimous one at that. This is fantastic. Thank you, everybody. So yes, indeed, international humanitarian law does apply even if the war is illegal under the UN Charter. And I loved everyone who weighed in with a yes, with an exclamation point. I absolutely love the exclamation point. Yes, it does. And this is one of the brilliant results of the drafting when we look at the UN Charter and we look at the Geneva Conventions and the subsequent treaties that came about that said, regardless of whether or not the war itself is legal in the first instance, so regardless of whether it's legal under domestic law or international law, we still have a recognition that international humanitarian law applies. And why is that? Obviously, because again, we want to go back to the reason why international humanitarian law exists in the first place, and that is to limit the destruction that can result from war. So if we have exceptions to the application of international humanitarian law, we would have exceptions to that limiting function, and that obviously cannot be our intention. So international humanitarian law, we always want to remember that regardless of the reasons, regardless of the justifications that are used in order to legitimize an armed conflict, regardless of whether one side of the party says that they are right and the other side is wrong, we have to remember that regardless of those justifications, international humanitarian law still applies, and it applies to both of the parties to the conflict. And so when we're talking about what one party is permitted to do and what one party is not permitted to do, we always want to remember and bring ourselves back to the basics that say, regardless of the legality of the armed conflict, in fact, international humanitarian law applies. Next slide, please. Joanna, I just reached up to change the slide and then I remembered, in fact, that you have that power. So up on the screen, I want us to bring us back a little bit to last night's lecture on human rights. And I want us to remember that human rights law exists at all times. And when we have a situation of peace, so that's on the left-hand side of the screen. So for those, so in order to describe what's on the screen, I can explain that there is a rectangle on one side of the screen. On the left-hand side, there is peace. On the right-hand side, there is armed conflict. And down the middle, we have three bubbles that straddle both situations of peace and situations of armed conflict. The top bubble refers to the protection of persons with disabilities. The second bubble is the freedom from torture. And the third bubble is the freedom from cruel, inhumane, and degrading treatment. And I put those three bubbles there in order to indicate that those protections exist during times of armed conflict as well as situations of peace. And what we see up in the slide is that the application of international humanitarian law applies just during situations of armed conflict. So when we're trying to unpack and see differences and similarities to international human rights law and humanitarian law, we can see that indeed both human rights law and international humanitarian law have protections, some of those fundamentals upon which we, those who are participating in the hostilities, governments, non-state actors, those are the fundamental protections that regardless of the situation, that those protections must exist and must be afforded to the individuals who are in need of that particular protection. So what we have to remember is that there's no situation, even in these extreme situations where we see a lot of Hollywood action movies, where you see a lot of discussion and debate about using torture and extreme measures in order to be able to get information from the captive. Even in those Hollywood blockbuster situations, it is not permitted to use torture in order to be able to obtain that information. The prohibition on the use of torture is an absolute under which I should say, we are never allowed to go under. And that also applies to persons with disabilities. So when we're talking about situations of armed conflict, when we are talking about the protections that must be given to individuals, we have to remember that both the provision of assistance itself, as well as choices around the means and methods of warfare, must take into consideration the protections that we must give to individuals with disabilities. And that is going to be discussed in much greater detail later on this afternoon. So a little bit of a quiz, just recapping what I've just said there. And I'd like you to finish this sentence again in the chat function in one of two ways. So international humanitarian law applies, and you can write in one of two ways: all the time or during times of armed conflict. So your two answers can be all the time or during times of armed conflict. So hopefully I'll see, oh, we have a mix here, all the time, all the time. We have a couple of people saying times of armed conflict. Great, times of armed conflict, all the time. Okay, all the time and times of armed conflict. Okay, times of armed conflict. So we have a little bit more of a debate and discussion here. And so what I would say, and again, thank you to everybody who's weighing in. I see lots of quick typing on the keyboard. That's fabulous. I'd say the majority of rules of international humanitarian law apply just during times of armed conflict. There are a couple of provisions under international humanitarian law that do apply at all times. For example, you have provisions related to the responsibility of governments and states to disseminate and spread the word and educate about international humanitarian law. That is an obligation under IHL that exists at all times. But the bulk of the provisions under international humanitarian law just apply during times of armed conflict. So that's related to the use of force, that's related to the choice of weapons, that's related to particular types of detention. And so the bulk of the provisions under international humanitarian law just apply during times of armed conflict. So what we have up on our slide is this arrow that indicates that human rights law continues to exist during times of armed conflict, as well as during times of peace, as was referenced last night on our keynote address. But then we have to recognize that in addition to human rights, which are going to be more circumscribed, likely during times of armed conflict, really our first law that we're going to look to during times of armed conflict is international humanitarian law. Why? because it is the law that is specifically designed, specifically written for those who are participating, those who are actively involved in armed conflict. So when we're talking about persons with disabilities during times of armed conflict, one of the first places we're going to look to is international humanitarian law. What do the Geneva Conventions say? What do the additional protocols say? And what do they say about the protection that needs to be afforded to different people? Joanne, next slide, please. So if you could click again, and I think maybe 2 clicks. So thank you, Joanne, that's wonderful. So when we're talking about our difference between situations of peace and situations of armed conflict. So on the previous slide, we had the 3 bubbles that went down the middle that indicated we had those protections that were straddling both situations of peace and situations of armed conflict. On this slide, we have a small diagram that shows that there's fighting going on within a particular territory. And on the screen, it says other situations of violence. So this is a situation that doesn't amount to an armed conflict. What do you mean, Catherine, when you say that? Well, in actual fact, what it means is we have situations in which there's potentially some violence, and it actually can be quite a high level of violence, but nevertheless, it doesn't meet the exact threshold, and it doesn't meet the threshold of an armed conflict. These can be situations where there's actually people dying. This can be situations in which there's destruction of the civilian infrastructure, but nevertheless, under the application of IHL, this type of situation of violence is still below the threshold in which international humanitarian law will apply. So if we could have the next slide, Joanne. On the next slide, you're going to see 2 new diagrams. So one, which is the situation in which you have one country fighting another country, and that is referred to as an international armed conflict. Joanne, if you could click again 2 times. The other situation that you can find yourself in is a non-international armed conflict. So the diagram on the screen shows that there's fighting taking place within a single country. So what that situation can look like is if you have a situation in which you have a state, so a government fighting a non-state actor, or you can have a non-state actor fighting another non-state actor. Now, if we're in a situation of a non-international armed conflict, that's going to be a situation that has to meet our 2 criteria. So if you remember the previous slide, I said we can have situations of violence, and that's a situation in which human rights law and all of our domestic law applies in full. But now that we're on to our next slide, we're transitioning into situations of armed conflict. And like I just said, you can arrive in these one of 2 scenarios. You can arrive in an international armed conflict or a non-international armed conflict. Now, if we arrive in a non-international armed conflict, we know that we've arrived there if we can find 2 criteria. One is that the level of violence is really quite high. So you have a large number of civilian deaths, you can have a large amount of infrastructure destruction, you can have a widespread scale of violence over both time and geography. In addition, the other criteria we have to find is that the parties to the conflict themselves are organized. They have to be able to execute particular military functions. They have to be able to engage and participate in the application of IHL. So when we're talking about, in my question that you guys just answered, does IHL apply in all times or during times of armed conflict? The times of armed conflict are one of 2. That of international armed conflict and that of a non-international armed conflict. So if we could have the next slide, please. So when we talk about international humanitarian law, what we're really talking about is striking this right balance between military necessity and that of humanitarian considerations. And when we talk about humanitarian considerations, we are talking about potentially the creation of disability, or we can be talking about persons who need protection, who need their disability factored into the response. So that way the humanitarian delivery of aid, the provision of particular needs of persons with disabilities is factored into that humanitarian response. And that is a responsibility of the states who, as well as the non-state armed groups who are participating in the fighting, as well as the humanitarian community who's participating in the response to the needs that have arisen because of the fighting. Next slide, please, Joanne. So when we talk about international humanitarian law, we have, again, our overarching idea that international humanitarian law is the law that governs the interaction between states and non-state armed groups during times of armed conflict, and as well as the fighting between non-state armed groups themselves. So when we talk about IHL, it has this very, very lofty ideal, this goal of that limitation of death and destruction, especially of the civilian population. So when we are to dive a bit deeper into IHL, there's two streams that I want us to think about when we're hearing our presenters later on this afternoon. The first stream, and you'll see this on the left-hand side of your screen, the screen says the rules that regulate protection of persons. So individuals as well as groups of people are protected under international humanitarian law. And those individuals need to be protected. They need to be protected from the impact of the fighting itself. They also need to be, as a party to the conflict, you cannot direct your attacks towards those individuals. On the second side of the screen, you'll see another box that says the rules that regulate the use of force and, quote, in quotation marks, the conduct of hostilities. So what this means is that under international humanitarian law, we have limitations on how the fighting can actually take place. So there's a limit on what soldiers, what combatants, what states, what they are permitted to do during times of armed conflict. So this results in a limitation in the types of weapons they're allowed to use, and we're going to unpack some of that shortly. You're going to hear about that as well later on this afternoon. You also have a limitation that doesn't just look at the impact on the civilian population, but also on the impact on the soldiers and the combatants themselves. So again, a bit of a recap. Under the rules of international humanitarian law, we have two streams that we want to think about. One are the rules that regulate the protection of persons. The second are the rules that regulate the use of force. And when you get into IHL circles, that is used, sorry, I keep on using my hands to put quotation marks, but we refer to that use of force and how the fighting is actually being conducted. We refer to that as the conduct of hostilities. So you'll hear me and others say that throughout the rest of our presentations. Joanne, if we could have the next slide. Great. So when we're talking about the conduct of hostilities and the rules that regulate them, one of our first principle is that of distinction. So you as a combatant, you as a soldier can only direct your attacks towards a lawful military target. So you have to distinguish between a combatant and a civilian. You also have to distinguish between a military objective and a civilian object. You also have an obligation to not direct your attacks towards specially protected individuals as well as places and things. So for example, I and others within the Red Cross Red Crescent movement, as well as the medical services of armed forces, they are permitted to use the Red Cross, the Red Crescent, or the Red Crystal in order to indicate their outward protection against direct attack. It's in order to indicate that, yes, indeed, we are providing neutral and impartial humanitarian assistance, regardless of the side that assistance is being provided to, and that a party to the conflict cannot launch an attack towards that individual who's providing that assistance. Now, in the distinction principle, you'll see up here on the screen, we have that difference between a combatant and a civilian, right? And you're allowed to direct your attack towards a combatant. But I have another question for you, and get your fingers on the ready. And the question is it lawful to inflict unnecessary suffering on a combatant? So the rule of distinction says you're allowed to attack a combatant, but are you permitted to inflict unnecessary suffering on the combatant. And I see they're approaching 30. Not at all. No, we have an overwhelming no with a question mark. No, of course, because IHL protects them. Excellent. So we have approaching 40 responses from people. Excellent. Thank you so much to everybody for weighing in on that. That is absolutely correct. Even when you are launching an attack against a combatant, there is a limit on what you are permitted to do. And that limit is that you are not allowed to cause superfluous injury or unnecessary suffering. So what is superfluous injury? It's a huge debate within the legal community as well as the humanitarian community. And this is a really interesting intersection within disability and IHL. One of the reasons why a weapon, blinding laser weapons, was deemed to be and argued to be and then found to be illegal under international law was the fact that you were intentionally causing blindness that would result in a disability for combatants that did not have a relation to the military objective. It was deemed that that injury to the combatants on the other side would be unnecessary suffering in order to achieve that military end. So even when we're talking about this distinction and attacks towards combatants, there is still an absolute limit as to, and that limit is the limitation on using means that will result in unnecessary suffering or superfluous injury, even with the combatant population. So it's always important when we're talking about international humanitarian law and we're talking about those who are going to be impacted and protected, as one of our questions and one of our answers came in through the chat function. No, because in fact, IHL continues to protect combatants with some of these limitations that say, yes, they can be attacked, but they're not allowed to be attacked in a way or with a means or methods of warfare that will result in them abstaining, or no, not abstaining, from them receiving or being a victim of superfluous injury and unnecessary suffering. Next slide, please. So our second principle, when we want to talk about the conduct of hostilities, yes, Francis, I see your question, and we will talk about that later on in our Q&A session. And definitely, there is a lot of debate and discussion about different types of weapons, how and when they can be used. We have the treaty that has come out because of nuclear weapons that a number of countries have signed on to. We also have limits on other weapons. And it's all, when you look at these treaties, particularly looking at weapons conventions, it's all about striking that balance, right? So remember, if you remember that slide a couple of slides ago, that was about finding the balance, because international humanitarian law exists within the regime, right? Exists within the legal regime that does only in 2 instances allows for the right to be able to resort to the use of force, right? But then when that right to use force then applies, we then have international humanitarian law. So for nuclear weapons, we turn to the ICJ advisory opinion. We look at what a number of states have said about the fact that the use of nuclear weapons would only be used in very extreme and very limited scenarios. And it could only be used against a lawful military target. And so we have a lot of debate and discussion within the IHL world about the use of particular weapons, chemical, biological, as well as nuclear, all saying, well, how can that weapon be used in such a way that it can be used in compliance with international humanitarian law? And we within the Red Cross and Red Crescent movement have said quite clearly that we find it difficult to envision where and how nuclear weapons could be used in compliance with IHL. Other states and other governments have different opinions on that. And yeah, lots of space for discussion there. So when we're talking about our principles of the conduct of hostilities, our second principle is that of proportionality. And under international humanitarian law, proportionality has a very particular definition. So what it means is that the anticipated incidental civilian death or destruction, it cannot be excessive in relation to the concrete and direct military advantage. I realize that's quite the mouthful. But what international humanitarian law says is that, again, proportionality demands that the parties of the conflict do a balancing, an incredibly difficult one. We could spend a year unpacking this and different attitudes, legal findings, and government opinions about the interpretation of proportionality. For the sake of today's presentation, we have to kind of skip through it a little bit, but it's understanding that you have to apply the principle of discrimination as well as proportionality, as well as our third principle that's coming up, and that it all must be applied cumulatively. Proportionality is where the idea of collateral damage comes from during times of armed conflict. And under international humanitarian law, collateral damage, so long as it is not excessive to the concrete and direct military advantage, can be lawful. And that is why it is an extraordinary step for international humanitarian law to apply to particular situations. If I could have the next slide, Joanne. And then our third principle is that of precautions. So ensuring that that all steps are taken, the feasible measures are taken in order to ensure that the principles of precaution, the principle of distinction are in fact abided by. So this is really a means by which a soldier, a combatant, a commander, they have to double check and make sure and verify that the attack that they're going ahead with is in compliance with international humanitarian law. Next slide, please, Joanne. So when we're talking about international humanitarian law, you remember from the slide a couple of slides ago that said we had rules under IHL. We've just gone through the rules that apply to the conduct of hostilities, so the weapons and the tactics, which again, we're going to dive deeper into this afternoon. And then now I'm going to talk briefly about those individuals who are protected under international humanitarian law. So very explicitly, as we've just covered with our question, we know that soldiers are in fact protected by IHL. And if we crack out, for those of you who know me, always I have with me my Geneva Conventions. Oh, you can there we go, can see it a little bit better. Without the sunlight reflecting. We know that the first treaty of the Geneva Conventions was focused on the first two treaties when they were written, were focused on the protection of the wounded and sick combatants. Then we have our third Geneva Convention was specifically designed for and written for those who are detained during an international armed conflict. And then our fourth under the Geneva Conventions is that looking at protection of civilians. When we talk about the additional protocols that apply, the first one applies to an international armed conflict, the second to a non-international armed conflict. We have further details that outline who is protected during armed conflict and what those protections are. So we know from the principle of distinction that civilians cannot be the subject of a direct attack. In addition to that protection from being directly the victim or directly the target of a direct attack, civilians also have to be protected from the general conduct and the general impact of the hostilities. They also have to be provided assistance so that way they can carry on with their daily functions. And that can be done by a party to the conflict. That can be done by humanitarian organizations, such as some of the organizations that are on the call with us today, including the Red Cross and Red Crescent movement. And you have this realization within the response to situations that arise during times of armed conflict, that when we respond to those needs, there are going to be particular needs of those who have disabilities, persons with disabilities, and that there could be the result of disabilities arising from the use of force and particular weapons. And so we've seen, for example, a rise in individuals who have lost limbs in conflicts in Afghanistan, for example, as well as countries all over the world. and that there therefore needs to be a humanitarian as well as a government response in order to be able to address the needs of those individuals that have arisen because of the particular use of different types of weapons. For example, in Afghanistan, explosive weapons and explosive remnants. So when we're talking about the protection, it's not just against that direct attack, right? So we know that that is prohibited, but we also know that the whole notion of protection also needs to be included when we're talking about our choice of weapons, when we're talking about the general impact of armed conflict on the civilian population, as well as the combatants who have been impacted by that armed conflict. Exactly, landmines. Thank you, Francis, for throwing that out there. We know in all the advocacy work related to landmines that those weapons resulted in large number of loss of limbs for the victims, and that has resulted in some debilitating and severe disabilities for all of those victims, soldiers, and civilians alike. So in addition to the individuals who and the general civilian population who are protected, we also want to be thinking about the individuals who are detained during a time of armed conflict or related to a time of armed conflict. So we have rules, again, we're going to turn to the additional protocols. We're going to turn to Geneva Convention 3 to tell us what are some of the specifics that are needed and required for those who are taking individuals, who are detaining them, and what assistance needs to be given to those individuals. And that includes individuals who have disabilities, and there's even reference within international humanitarian law, as well as some of the subsequent treaties that have come about, especially related to weapons, about some of the rehabilitation that actually needs to be given and afforded to individuals who have suffered as a result of armed conflict, and what they need in order to be reintegrated. So when we look at the protections under IHL, we're talking about protections of the civilian population. We're talking about protections of those who have been wounded and sick. We have protection of those who are detained. And when we're looking at all of those protections, we look at gender, we look at all the different ways and grounds by which an individual, what protection they need and what assistance they need in order to be able to navigate the negative impact of armed conflict. So moving on to our last section of this presentation. So Joanne, if I could go to the next slide. And I'm hoping that I'm going to get lots of answers for this question. So when we talk about international humanitarian law, we also always want to be aware of what are the impact and what are the responsibilities of those who violate IHL, and what is the responsibility of those who are responsible to enforce international humanitarian law. So again, when we look at our legal framework, we know that the Geneva Conventions, additional protocols talk about the responsibilities to ensure that there is a regime to ensure accountability for IHL. There are responsibilities to repress and suppress violations of IHL. And this is where we have this interaction between humanitarian law that tells the parties to the conflict, no, you are not permitted or you are permitted to do these particular types of things during armed conflict. An international criminal law that says these are the consequences for violating international humanitarian law. So my last question to you is as follows. Throwing out in the chat function, can you name different national and international courts and tribunals that are responsible for dealing with violations of international humanitarian law? So the question is again, can you name national and international courts and tribunals that are responsible for dealing with violations of IHL? So I see a lot of ICC. Great. I see a courts martial. I see for those who are using acronyms, can you spell it out? Just so that way everyone on the call knows what we're seeing. So I'm seeing a lot of ICC. I'm assuming people mean International Criminal Court. Wonderful, thanks for that. International Court of Justice. We have a national court. Wonderful. We have the extraordinary chambers in the courts of Cambodia. This is fantastic. Thank you so much. And yes, you are correct. We have national courts. So for example, in Canada, we have under the War Crimes and Crimes Against Humanity Act, there is a jurisdiction for various courts within Canada to be able to deal with violations of IHL. Absolutely, we have military justice. Thank you for the person who put that down under courts martial, as well as the various levels of military justice, where combatants and soldiers who are members of the armed forces can be held accountable for violations of IHL. Moving up, so we have our military courts, we have our national courts. You can have regional courts that are responsible for violations of international humanitarian law. Then you can have some of the individual courts that have been set up, obviously for Rwanda and Yugoslavia. And then we have the International Criminal Court. So when we're talking about an accountability regime, we have to remember that there are a number of ways by which individuals can be held accountable for violations of IHL, including for those violations related to persons with disability. So, Joanne, I hand the floor back to you, and I believe my responsibility right now is to let everyone know that we are going to be taking a 15-minute break. We very much look forward to having you join us again. I personally would like to thank everybody for your participation in the group chat. Great to see all of those questions coming in and those answers. And we look forward to seeing you in 15 minutes. Thank you very much for your time, everybody.